anyone is recording this, but
we do a live broadcast through YouTube. So really, we can't check that. We just need to use everybody's, everybody just has to agree that if you want it recorded or if you don't. But yes, we don't have a way to check right now.
Well, let me ask then real quick, if someone from the prosecution could let me know if there's any objection to recording this proceeding.
There's no objection, Your Honor.
And from the defense?
No objections, Your Honor.
Okay, great, thank you. So the Colorado Bar Association may be taking photographs of the competition or screenshots, I guess, in this case. So just make sure that by participating in this, you may have photos or screenshots appearing in next year's challenge and packet. If anyone is in the gallery or out of sight here that is not competing, so student members or coaches from other schools or from the same school or a different team, I do need you to leave the room at this point in time. Please make sure, in fairness to the people that are competing, that you're not here if you're not supposed to be. I'll remind both teams that there are no recesses allowed unless it's for an absolute emergency, but feel free to let me know. If it's an emergency, let me know and we can take a recess, but we want to make sure we give you enough time to debrief with your coaches before your next round. At this point in time, I would like to ask this panelist to go over the participants for each side. If you could look at their names to see if you would have any reason to be biased in judging either team. And again, you're probably going to need to look at the rosters to be able to make that determination. If you don't see, oh, Deanna, I'm sorry.
Yes, please. If you could actually, if all of the participants could please turn on their cameras. I tend to occasionally miss a name, but not the face.
I think that's fair. Yeah, thanks, Deanna, for saying that. And thank you for every participant turning their camera on. I'll give the panelists a moment just to look. And again, panelists, if you just give me a thumbs up if you don't see any conflicts, I would appreciate that. A thumbs up on the camera. Keith, thanks. Marion, thank you. And Deanna, thank you. Okay.
And then scoring panelists, we'll have you stop your videos as well just during the competition. And then hopefully on the screen, it will just be those people whose videos are going that students and you all will see. Makes it a little bit easier to watch and all that good stuff. Great, thank you.
And Melissa, before we jump in, then I think I'm just supposed to wait to make sure we're okay to go forward since we don't have any conflicts.
Yes, as long as you don't have any conflicts, you are good to go right now.
Okay, so we're going to get started soon, I promise. Teams and coaches, please remember any disputes that arise out of this competition must be reported in accordance with the tournament rules. Please, both teams remember that there are time requirements and timekeepers are to follow the rules to make sure that they're keeping track of your time. And at this point in time, I would like to go ahead and start with the people, the prosecution. If you could go ahead and introduce the participating team members, both attorneys and witnesses. And again, is there someone from the prosecution who can introduce the members of their team, please?
Yes, it appears my video. Okay, there we go. Good afternoon, Your Honor. My name is Emma Klausner, and I will be performing the direct examination of Detective Jordan Markowitz and the cross-examination of Taylor Perkins.
Thank you, Ms. Klausner.
Do we have the other members of Greece that can, thank you.
Yes, good afternoon, Your Honor, opposing counsel and ladies and gentlemen of the jury. My name is Laura Thompson, and I will be performing the direct examination of Kyle Kuzak, the cross-examination of Blake Van Owen, as well as the opening arguments.
Thank you, Ms. Thompson.
Good afternoon, Your Honor, opposing counsel, and ladies and gentlemen of the jury. My name is Raven Chamberlain, and I will be doing the direct examination of Alex Cifuentes and the cross-examination of Avery Becker, along with the closing arguments. May our witnesses please introduce themselves.
Thank you, Ms. Chamberlain. And the witnesses can introduce themselves. I apologize.
Good afternoon, Your Honor, and ladies and gentlemen of the jury. My name is Abby Miller, and I will be playing the role of Detective Jordan Markowitz this afternoon.
Thank you, Detective.
Good afternoon, Your Honor, and ladies and gentlemen of the jury. My name is Rachel Yett, and today I'll be playing the role of Kyle Kuzak.
Thank you.
Good afternoon, Your Honor, and members of the jury. My name is Shanti Grossman, and today I'll be playing the role of Alex Cifuentes.
All right, thank you so much. And I believe that's all from the people, or, oh, timekeeper, I'm sorry, go ahead.
Yes. Good afternoon, Your Honor, and ladies and gentlemen of the jury. My name is Reham Abdunabi, and today I will be the timekeeper.
Thank you so much, and I apologize for cutting you off there. Thank you. And will the defense go ahead and introduce themselves, please?
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Cindy Nguyen, and I will be performing the opening statement, the direct of Avery Becker, and the cross of Detective Jordan Markowitz.
Thank you.
Good afternoon, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Maggie Holland, and I will be providing the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, as well as representing the Keystone attorney.
Thank you.
Good afternoon, good afternoon, Your Honor, late members of the jury and opposing counsel. My name is Raina Hilden, and today I will be providing the cross-examination of Kyle Kuzak, direct examination of Professor Blake Van Owen, as well as the closing arguments. At this time, we ask that our witnesses may introduce themselves.
Yes, please, thank you.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langen, and I am Avery Becker.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Lucy Ingram, and I am Taylor Perkins.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Sarah Mazer, and I am Blake Van Owen.
Thank you so much. And I believe that's everyone from the defense. Or, I'm sorry, do I have a timekeeper? Did I miss that?
Yes, Your Honor. My name is Hannah Moskowitz, and I will be the timekeeper for India.
Thank you so much. All right, I'm going to go ahead and swear everyone in so we can get started. First, team members, no need to turn your cameras on, but I am going to ask that you raise your hand. Please raise your right hand. And I do need you to respond audibly, please. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. Witnesses, if you would raise your right hands, do you promise that the testimony you are about to give will faithfully and truthfully conform to the witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. And gallery members, anyone watching, including teachers, attorney coaches, family members, and friends, you also please need to raise your right hands. And in this case, no need to turn on microphones if you don't have access to them, but please still say this out loud. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And finally, scoring panelists, again, you can stay off camera, but please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
I will assume our last panelist agreed to that.
Yes, Your Honor.
Thank you. I wasn't very clear there on whether you needed to say it, so I apologize for that. Well, I would like to go ahead and call to order case 20 CR 3103. The parties have already entered their appearance. This is the people of the state of Colorado versus Avery Becker. Before we get started, are there any preliminary matters that the court needs to address?
Yes, Your Honor. The prosecution would like to inquire into the court's preference on screen sharing, when to do so.
You know, I will defer to counsel in terms of how to go about screen sharing. I don't have a particular preference, and I kind of will just say let's maintain flexibility in case something doesn't go as planned, and we can adjust as needed, okay? But I don't have a particular preference on how you use screen sharing. The one caveat I'll give, I'm sorry, is of course, if you're not actively examining a witness, I ask that you don't share your screen. Whoever is conducting the examination should be controlling the screen sharing.
We'd also like to ask if redirects and crosses will be allowed.
Redirect and cross-examination will be allowed, but remember that the redirect does count against your overall time, so you need to allocate that accordingly.
We'd also like to mention that our team is all competing from the same school, and in between the exchange of witnesses, we may need a moment to sanitize the area, and we apologize in advance for any delay.
Thank you for the heads up, and I think given the world we're all living in, that's certainly understandable. But thank you, Ms. Klausner, for telling me that.
Yeah. And that's all.
Thank you. And any preliminary matters from the defense?
Yes, Your Honor. The defense, in regards to the screen sharing order, we would ask permission for trial technicians to display exhibits on the screen for the purpose of entering them into evidence, or if they have already been entered to evidence for expediency's sake.
Yeah, thank you, Ms. Holland, for clarifying that. That's granted. That's not a problem. And what we'll do is we're just going to assume that if you need to get an exhibit entered, we'll just sort of act as if you're laying the foundation in front of the judge if there are any issues, and then we can proceed the way you suggested. That sounds good.
All right, and then we would ask that the exhibits, once they have been entered, would be constructively published to the jury, but they will just remain on the screen.
Yep, and for our scoring panelists, just so you guys know what that means is once that exhibit has been admitted, we're not going to require lawyers to give you an actual copy or send it to you. We're just going to consider it that it's published and that you have access to it. Thank you, Ms. Holland. That's anything else?
Lastly, in the event that someone is having technical difficulties, we ask permission for them to momentarily turn off their camera in order for the sound quality to improve.
Absolutely.
Thank you, Your Honor.
Thank you. So that concludes the preliminary matters. Before we go to opening statements, are there any substantive motions that either side would like to address? Any motions in limine?
No, Your Honor, there are not.
Okay. And from the defense, are there any motions in limine?
No, Your Honor.
Okay. All right. Would the people like to proceed with opening statements?
Yes, Your Honor. Are timekeepers ready?
Yes, I'm ready.
I'm ready as well.
Good afternoon, Your Honor, opposing counsel, and ladies and gentlemen of the jury. Get out, get in, get even. Today you will hear the story of Mackenzie Brackman, a successful defense attorney. He worked day in and day out tirelessly, helping people that normally wouldn't get a second chance. With the limited free time he had, he spent that time coaching a high school mock trial team. Some of the kids on his team were Alex Cifuentes, Taylor Perkins, and Avery Becker. Alex Cifuentes respected Mr. Brackman. They saw how hard he worked and how much he cared about the team. Then there was Taylor Perkins. Taylor Perkins never had a problem with Mr. Brackman. Again, they saw how much he wanted the team to succeed. Lastly is Avery Becker. Avery Becker always argued with Mr. Brackman, and their constant strife caused stress on not just the two of them, but the team as a whole. During one heated argument between the two of them, Avery Becker became completely disrespectful to Mr. Brackman in front of the whole team. So Mr. Brackman said that he had enough. He said, "Get out. Get out of practice and get out of my life." So Avery Becker became impulsive. And so they took a permanent marker and went to Mr. Brackman's 911 Porsche. They wrote Worst Attorney Award, all 18 letters. And of course, afterwards, they felt horrible about it. But this proves that Avery Becker, the defendant, is able to act on their impulses. On March 6, 2020, an intruder matching the height and build of Avery Becker got into Mr. Brackman's house and with the intent to vandalize his home. Once he got in, Avery Becker got even. That resulted in the death of Mr. Brackman. He was stabbed in his shoulder and left to bleed out. Today, the prosecution will call 3 witnesses. We'll call Detective Jordan Markowitz, Kyle Kuzak, and Alex Cifuentes. Detective Jordan Markowitz and Kyle Kuzak, with their expertise in investigative work, will tell you through ring videos that an intruder matching the height and build of Avery Becker, the defendant, got into Mr. Brackman's residence on March 6th. Then you'll hear from Alex Cifuentes, a teammate of Avery Becker. They'll tell you how bad the relationship was between the two of them and how much they argued. They'll also present you with text messages from Avery Becker not long before the murder of Mr. Brackman, where Avery Becker told them that they would get into Mr. Brackman's house and that they would get even. Then you'll hear from the defense. They will also call 3 witnesses. They'll call Blake Van Owen, Taylor Perkins, and Avery Becker. Blake Van Owen will try and tell you with their limited experience what they believe to be the holes in our case. But as you'll realize, their theories lack factual evidence. Then you'll hear from Taylor Perkins, a best friend of the defendant Avery Becker. They'll try and tell you that Avery Becker would never do anything like this, but they won't be able to hide the fact that Avery Becker did not like Mr. Brackman. Because of their friendship with the defendant, their whole testimony is biased, and they'll admit that they would do anything to make sure their friend was out of harm's way. Lastly, you'll hear from Avery Becker. Avery Becker will try and portray their relationship as not that bad, but they won't be able to hide the fact, yet again, that they didn't like Mr. Brackman and that they constantly argued with them. As you hear the prosecution's case, you'll hear 3 things to be true. That Avery Becker was told to get out of practice. Avery Becker got into Mr. Brackman's house, as shown through ring videos, on March 6th, and Avery Becker got even. The prosecution has the burden of proof. That means we must prove to you beyond a reasonable doubt that Avery Becker is guilty. As you hear the prosecution's case, you'll realize that there is no burden. There is just proof that Avery Becker was told to get out. Avery Becker got in, and Avery Becker got even. The prosecution asks you to find Avery Becker guilty on all accounts. Thank you.
Your Honor, I believe you were muted.
Thank you for that. I apologize. Will the defense be putting on an opening statement?
Yes, Your Honor.
You can proceed. Thank you.
May it please the court, Your Honor, members of the jury, and opposing counsel. Good afternoon. My name is Cindy Nguyen, and along with my co-counsel, Raina Hilden and Maggie Holland, we are honored to be representing the defendant, Avery Becker. On March 6, 2020, the Colorado High School mock trial team's coach, Mackenzie Brackman, was murdered in his own home. My client, Avery Becker, stands here today accused of this horrific crime. But the truth of the matter is that she did not do it. The prosecution jumped to conclusions and fell short in investigating the killer of Mackenzie Brackman. Now, the law provides that all defendants are innocent until proven guilty. The burden of proof is borne by the prosecution, and they must prove my client's guilt beyond a reasonable doubt, which they will fail to do because of their flawed investigation. You're going to see screenshots between Avery Becker and Alex Cifuentes. However, beware of Alex Cifuentes' bias against my client. Alex was another member on the mock trial team who is not happy with Avery Becker's accomplishments And today, she stands on the side of the prosecution, claiming that my client sent these messages. Furthermore, you will hear that the prosecution jumped to conclusions and fell short in failing to authenticate these messages. You're going to see pictures of cell tower diagrams tracking my client's phone on the day of the murder. However, that cellular device does not represent the whereabouts of Avery Becker, as she lost her phone the day before. Furthermore, these cell towers will not be reliable as they cannot pinpoint the exact location of a phone, as they can reach up to 6 miles away. You're going to see videos of a masked intruder unlawfully entering Mackenzie Brackman's home. The prosecution will claim that my client has the same build as this intruder. However, the prosecution jumped to conclusions and fell short in failing to investigate another person with the same build and body shape as the intruder, someone with a greater motive to kill Mackenzie Brackman, and that person is Blair Rollins. You see, a few months before the murder, Mackenzie Brackman failed to represent a man named Jonathan Rollins against a murder charge, and Jonathan Rollins was convicted and sentenced to life in prison. From his imprisonment, Rollins' child lost a father. Now that child, Blair Rollins, could be an equal suspect in this case, but once again, the prosecution jumped to conclusions and fell short in failing to investigate any suspects other than my client. Now the defense will call upon 3 witnesses, Avery Becker, Taylor Perkins, and Blake Van Owen. The defendant, Avery Becker, was a naturally gifted, award-winning attorney on the mock trial team. You will hear that Ms. Becker and Mr. Brackman did not have a great relationship. However, despite these conflicts, you will hear that Ms. Becker attempted to make amends with Mr. Brackman up to the day of his death. And while the two did not always see each other eye to eye, they were on the same team, the mock trial team. Our second witness, Taylor Perkins, will testify that my client was with Perkins the entire day of the murder. The two spent the day retracing their steps at the mall and the Fry Shack, searching for the missing phone. Taylor Perkins will testify under oath that Avery Becker has an ironclad alibi for the date and the time of the crime. Our third witness, Blake Van Owen, will dispute the prosecution's claims of how the murder was carried out, and she will question the validity of every piece of evidence that the prosecution collected during their investigation. Not only was their investigation sloppy, but they managed to lose pieces of evidence as well. Like I said, the prosecution is not interested in the truth. They're simply jumping to conclusions to get a quick conviction. At the end of this trial, my co-counsel, Raina Hilden, will recount the instances in which the prosecution jumped to conclusions and fell short in procuring the evidence presented to you today. Again, in order for my client to be deemed guilty, the prosecution must meet the burden of proof, which is to prove Avery Becker's guilt beyond a reasonable doubt, which they will fail to do. At the end of this trial, we will ask you to rule in favor of the defense and acquit Avery Becker of her coach's murder. The evidence will show that Ms. Becker is not guilty. Thank you.
Thank you, Ms. Nguyen. And let's go ahead and take just a brief moment for our scoring panelists. And one other thing I want to say before we move on to direct examinations is whoever plans on objecting, this might be obvious, but you have more practice in this than I do, but you may want to have your microphone unmuted to be able to object quickly to make sure your objection is timely. But I understand there may be some delay, and we'll just work through that the best that we can. If I don't hear that we need more time for the scoring panelists, would the prosecution like to call their first witness to the stand?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
And Detective Markowitz, you've already been sworn in, so counsel, you can proceed with your direct examination.
Okay. Detective, please state your first and last name, spelling the last for the record.
My name is Jordan Markowitz, and Markowitz is spelled Markowitz.
What's your current occupation, Detective?
I'm currently a homicide detective.
Who are you employed with?
The Denver Police Department, or the DPD.
How long have you been working with the DPD?
13 years now, but 7 years as a homicide detective specifically.
As a homicide detective, what exactly is it that you do?
As a homicide detective, I am called to the scenes of reported homicides, typically after uniformed officers and paramedics have secured a crime scene. Dispatch calls me, I report to the scene and look at the evidence that's present to start to put some of the puzzle pieces together.
And detective, do you work with any other fields of expertise that help you to understand investigation better?
I do, yes. I happen to be certified in cell phone technology and forensic data recovery.
Do you feel that that knowledge aids you and others in many cases?
I do, absolutely. I not only use this training and certification in my work constantly, but I found that it is very helpful in aiding juries' understanding of this really complicated technology.
And could you explain to me what exactly this technology is?
Cell phone technology is the science of how your cell phone works, especially when it's communicating with cell towers. Think if you're sending a text or making a call, your phone makes a communication with typically the most nearby cell tower, and those communications are recorded on CDRs or call detail records. And then on the forensic data side of that, it's being able to take and interpret those CDRs or call detail records and use them in forensic data and police work.
Your Honor, at this time, the prosecution moves to admit Detective Jordan Markowitz as an expert witness in homicide investigation and cell phone data analysis.
Does the defense have any objection?
Your Honor, may I perform a brief voir dire?
You may, and I'm going to ask that you limit it only to the scope of qualifications of this witness, please.
Yes, Your Honor. Detective Markowitz, your training in cell phone technology and forensic data recovery was only 3 days?
3 intensive days, yes.
Your Honor, at this time, I have no objections to Detective Markowitz being admitted as an expert in criminal investigation. However, I object to the specialization in the field of cell phone technology and forensic data recovery, as I believe that 3 days of training is not sufficient to prove that the witness is specialized in this field.
Do the people have a response?
Yes, Your Honor. Although the training was brief, the detective has instigated her knowledge and skill in a number of cases. She's quite experienced in it and therefore qualifies as an expert in the field.
The court is going to recognize Detective Markowitz as an expert in homicide investigations and in cell phone technology and data recovery, finding that the experience of this witness is sufficient to meet the threshold under 702. So you are recognized as an expert, and Ms. Klausner, you can continue with your direct examination.
Thank you, Your Honor. Detective, I want to direct your attention to the date of March 6, 2020. Is there anything significant to you about that day?
Yes, on March 6, 2020, I was called to the scene of a reported homicide at 444 South Flower Street.
What state was that in?
Colorado.
And what was the county?
Denver County.
What kind of building was 444 South Flower Street?
It was a residence or a dwelling. Someone lived there.
What were your initial observations upon your arrival?
My initial observations when I arrived at the scene were not only a body that I found laying face down at the scene, but a large chef's knife laying near the body covered in blood.
Were photos taken of them?
Yes, both.
Would you recognize those pictures today?
I would.
Okay. At this time, I'm going to go ahead and screen share exhibits 3 and 5. Detective, first looking at exhibit 3, can you see this picture?
I can, yes.
is it of?
It is of the body that I found present at the scene as it appeared.
Do you recognize the photo?
I do, yes.
Is it an accurate copy of the picture taken at the scene?
It is, yes.
Okay, and now as I scroll down to Exhibit 5, what is this photo, Detective?
This is a photo of the large knife that I mentioned earlier that was found near Mr. Brackman's body at the scene of the crime.
Is it an accurate photo of that knife?
It is, yes.
Your Honor, at this time, the prosecution moves to admit Exhibits 3 and 5 into evidence.
Any objection?
No objections, Your Honor.
Exhibits 3 and 5 are admitted and published to the jury.
Okay, I'm gonna go ahead and stop sharing my screen at this time. Detective, after initial investigation, were you able to obtain any other types of evidence?
I was, yes. I was not only able to obtain CDRs, which we discussed earlier, but I was able to obtain video evidence relevant to this case.
What kind of video evidence was that?
I was able to obtain videos from Mr. Brackman's Ring video account. Ring is a sort of dual system. It serves as both an audio and video surveillance system, and Mr. Brackman happened to have one installed. And through my investigation, I was able to obtain account data and passwords for Mr. Brackman's Ring account, and through that, pull some relevant videos from his account for this case.
Did Mr. Brackman have multiple of these Ring video cameras?
He did, yes, he had 3.
Were you able, would you recognize the videos if you were to see them today?
I would, yes.
At this time, I am going to screen share Exhibits 10 and 12. First, looking at Exhibit 10, Detective, do you recognize this video link here?
I do, yes.
What does it appear to be a video link to?
It is a link to one of the relevant videos that I pulled off of Brackman's Ring video account.
And is it an accurate depiction of that link?
It is, yes. This is the exact link I pulled from Brackman's account.
Okay, scrolling down to Exhibit 12, do you recognize this video link, Detective?
I do.
What is it a link to?
It is a link to another one of the relevant videos pulled off of Mr. Brackman's account by me.
Is this video taken from a different location than the first?
It is, yes. As we discussed earlier, Mr. Brackman had 3 Ring video cameras, and this is taken from a different camera than that first one that we discussed.
And Detective, do you recognize this video link as an accurate link to the video?
I do, yes. This is once again the exact link that I pulled from Mr. Brackman's account for this video.
Your Honor, at this time, the prosecution asked to admit Exhibits 10 and 12 into evidence.
Any objections from the defense?
Yes, Your Honor. Under Rule 403, Exhibit 12 should be excluded for being cumulative. It doesn't offer any value that Exhibit 10 doesn't already cover, which wastes time. And there's no question that an intruder did enter the home. And so Exhibit 12 simply shows the intruder entering the home.
And do the people have a response to the objection that Exhibit 12 is cumulative?
Yes, Your Honor. This exhibit isn't cumulative because it's taken from a different location than that of Exhibit 10 and therefore is providing different information.
And counsel, about how long are each of the videos?
I would have to check after admitting. I can't quite remember the timestamps, but each are under 30 seconds.
The court notes the objection, but overrules it and is going to allow both Exhibit 10 and 12 into evidence.
Okay. Detective, looking back at Exhibit 10, I'm going to go ahead and play this video. As we watch it, what do you see happening?
In this video, we can see an intruder, later identified as the defendant in this case, dressed in a full disguise. They're wearing a Halloween mask, a hoodie, dark clothing, and gloves. And we see them walk up to Mr. Brackman's front door, which seems to be locked as they attempt to enter through it. And then as they are unsuccessful in their entrance, they turn away.
And then looking back at Exhibit 12, which is down here. Sorry for that. I'll go ahead and play this video. Detective, what do we see here?
In this video, we see the same intruder, once again, later identified as the defendant, as we see them dressed in the same disguise, open Mr. Brackman's front door in an attempt to enter, and we see them be successful in doing so as they walk through Mr. Brackman's back door and then slide it closed behind them.
Okay, I'm gonna stop sharing my screen at this time. Detective, through viewing these videos, were you able to come to a conclusion on if you thought the defendant's entrance was welcomed or forced?
I was, yes.
What was your conclusion?
My conclusion was that this entrance was in fact forced, as we see the same intruder attempt to enter Mr. Brackman's residence through two different entrances and not hold any keys or other methods of entrance into this house. I was able to determine that this entrance was not only unlawful, but it was in fact forced.
Detective, after viewing these videos, you mentioned that you were able to obtain CDRs in this case. Were you able to create any kind of visual representation of them?
I was, yes. CDRs are quite hard to understand if you don't know what you're looking for. And so I took the CDRs and turned them into diagrams, which show not only the ranges of relevant cell towers, but those overlaid over a map showing Mr. Brackman's home.
Detective, how do CDRs pertain to this case?
They pertain to this case as I was able to obtain them for the defendant Avery Becker's phone.
Okay, at this time, let the record reflect that I'm going to screen share exhibits 15 and 16. Can you see these diagrams, Detective?
I can, yes.
What can we see of the defendant's location through these diagrams?
In these two diagrams, we can't see the defendant's location specifically, but we can see the location of the defendant's phone and by extension, the whereabouts of the defendant on March 6, 2020.
At this time, Your Honor, the prosecution asked to admit exhibits 15 and 16 into evidence.
Any objection from defense?
Yes, Your Honor, two objections. My first is that these exhibits are cumulative, as the info that the witness intends to speak to can be covered by only one of these pieces of evidence. And my second objection is that this evidence should be excluded under Rule 403 for misleading the jury. The evidence only shows that the phone is in the vicinity of these towers at these times. However, the cell towers are not like GPS and therefore cannot track the real or the route that the phone traveled on.
All right, so right now there's an objection for cumulative under 403 and misleading under 403. Do the people have a response?
Yes, Your Honor. These exhibits aren't cumulative because displaying exhibits 15 and 16 allows for the jury to see all aspects of the process that the detective took in her investigation through these diagrams. Misleading the jury objection is it's not misleading the jury because the exhibits show the defendant's phone throughout the day exactly as how it traveled. and this is indisputable evidence.
The court is going to overrule defense's motion and allow both exhibits to be admitted into evidence. And Ms. Nguyen, if you do want to cross on either of the topics you raised, you can feel free to do so.
Your Honor.
Detective, through your knowledge and experience, does the evidence shown in this case give you an idea of where the defendant was near the time of Mackenzie Brackman's murder?
Yes.
Where would that be, Detective?
That would be in the same cell tower range in which Mr. Brackman's home falls.
Thank you. Your Honor, no further questions.
Any cross-examination?
Yes, Your Honor.
You may proceed.
Detective Markowitz, you reached several conclusions for today's trial, and I would like to talk to you about the evidence you collected to come to these conclusions. Let's start with the evidence at the crime scene. Pictures were taken of blood spatter inside Mackenzie Brackman's home, correct?
Yes, by the team that reported, yes.
However, the digital files in the camera became corrupted and could no longer be recovered.
Yes, in our process of investigation, yes.
Now, I would like to direct your attention to the ring videos in Exhibit 10. Let the record reflect that the trial technician is screen sharing what has previously been marked as Exhibit 10. And the trial technician will stop at 4 seconds. You claim that this is Avery Becker, correct?
Yes.
However, if you could answer these questions with a simple yes or no. You don't know the race of the person in this video.
No.
You don't know their age.
No, we cannot see that in this video, no.
You don't know their gender.
Not from this video, no.
And so you reach the conclusion that this is Avery, even though you don't have any concrete evidence of their characteristics. Besides
not through. Oh, I'm sorry, excuse me?
You concluded that this is Avery, even though you don't have any concrete evidence of their characteristics besides an approximate height and build.
That in addition to the CDRs discussed earlier.
And Brackman was a criminal defendant, correct?
He happened to be, yes.
So this could also be a disgruntled ex-client of Mr. Brackman's like you proposed?
Yes, I initially thought that, but after further investigation, it became clear that that was not the case.
And Jonathan Rollins was an ex-client of Mackenzie Brackman's?
I believe so.
Now moving on to the cell tower diagrams, the phones connect to towers with the strongest connection.
Yes.
So that means a phone could connect to a tower further away.
It could. It's highly unlikely, but you're right, it could.
And call detail records cannot pinpoint the exact location of a phone like GPS.
No, but they do a good job in telling us the general location.
And there's no way to determine who is in possession of the phone at that time.
Excuse me, sorry, I couldn't quite hear the end of your question there.
There's no way to determine who is in possession of the phone.
Which phone are you speaking of, Avery's?
Through the call detail records, you cannot tell who is in possession of the phone.
Excuse me, no, you can't.
Now, directing your attention to one of your witnesses that led you to this conclusion, Alex Cifuentes. Cifuentes was your biggest lead in this case?
He was, yes. He also happened to be, yeah, he was.
And this lead was of text messages sent between Cifuentes and who she claims is Avery Becker.
Yes, as in addition to other things that were detailed in my interview with Ms. Cifuentes. Yes, absolutely.
However, you didn't take this evidence directly from Cifuentes' phone.
I did, yes, I did.
So it's your testimony that you took this evidence directly from the phone?
By way of screenshots, yes.
So, however, you never had the actual device in your hand?
I did not, no, just the screenshots.
And you didn't try to reschedule another day to obtain the device?
I did not know. After I received the screenshots from Ms. Fuentes, I did not believe it was necessary.
And you asked for the screenshots?
I did, yes, from Ms. Fuentes, yes.
However, you didn't receive them until an entire day passed.
I did not. No, Ms. Fuentes mentioned something about having phone troubles, and so I just figured it was that.
So you didn't see what messages preceded or proceeded, the ones shown in the screenshot?
I did not, no.
And no forensic data recovery operations were performed on this phone?
Not on this phone, no.
And the screenshots don't explicitly show a number that is or is not Avery Becker's.
No, they show the contact name Avery Becker.
However, not a phone number.
Not a phone number specifically, no.
And Detective, you acknowledge there are ways to forge a text conversation, correct? Like perhaps through a text messaging app?
Yes.
And it is also relatively easy to change the name of a contact, correct?
It is, yes.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor, a brief one. Detective, through talking to Alex Cifuentes, did you feel it was necessary to have any more than screenshots?
I did not. No, Alex was a trustworthy kid and explained to me enough in our interview that I believe screenshots would suffice.
And Detective, you didn't suspect any foul play within those messages, did you?
I did not know. As we'll see if we see the text messages later, who is texting who is clearly laid out, and so no.
Thank you. No further questions.
Thank you. Would the people like to call their next witness?
Yes, Your Honor. I'm calling Kyle Kuzak to the stand, and it will take 1 second to sanitize the area and make sure everybody's connected.
No problem. That'll probably give our panelists some time to score. So you can proceed whenever you're all set up.
Thank you. And just to let you know, we are having a few camera issues, so there's a slight delay for it to turn on.
No worries. Thank you for the heads up.
Of course. Please state your name, spelling your last for the record. And I'm sorry, we cannot hear you, Miss Kuzak. And if the time could be stopped while we deal with this technical issue, that would be much appreciated.
If there are issues connecting, if you you can close Zoom and reopen, and I can let you back into the room if you can't get this fixed right away.
If I can ask that Ms. Kuzak try speaking into the microphone to see if we can hear her.
Looks like she's maybe not getting any feed, audio or video. We'll give them a couple minutes to figure it out.
Thank you, Your Honor. I'm sorry about the wait.
No worries. This is how it works with Zoom, and we've all experienced it. So we'll all hang tight and try to get it up and running.
I'm so sorry, Your Honor. Can you hear me now?
I can hear you.
Okay, awesome. I'm so sorry about that.
And the only thing I will say for our scoring panelists is counsel for the people, There's no need to change the name that's listed on her screen, but can you just clarify the witness that's being examined right now?
Yes, so this is Kyle Kuzak.
All right, it looks like we're up and running. Counsel, you can start your direct examination.
Thank you. Please state your name, spelling your last for the record.
My name is Kyle Kuzak, Kuzak.
What line of work are you in, Ms. Kuzak?
I'm a crime scene reconstruction investigator.
What does that mean exactly?
Well, I work closely with the local police force, and I get called to scenes to identify event segments and sequences of when they happened.
How long have you been in this line of work?
I've been doing crime scene reconstruction for 19 years, but I've spent the last 3 years of my work with the City of Denver Police Department.
So are you considered a police officer?
No. I'm a civilian employee.
How do you get your cases assigned?
Well, like I said, I work closely with the local police department, and basically, if they come across a crime scene that they decide they need help evaluating or reconstructing, they call me in.
And have you attended any conferences or training for your line of work?
Yes, I've been to multiple crime scene reconstruction conferences, and I'm also certified with the Colorado Bureau of Investigation.
Your Honor, at this time, the prosecution asks to admit Kyle Kuzak as an expert in crime scene reconstruction investigative work.
Any objection from the defense?
No, Your Honor.
All right, the court will recognize Ms. Kuzak as an expert in crime scene reconstruction and investigation, I believe.
Yes, it's crime scene reconstruction investigative work.
Thank you. All right, this witness is recognized as an expert, and you can continue with your examination.
Thank you. Ms. Kuzak, were you assigned to the murder of Mackenzie Brackman?
Yeah, I was. The Denver Police Department decided they needed my help on this, and given my experience with home invasions and homicides and, home crimes, that I was called there.
What did you notice when you first got to the scene?
Well, I just started doing my crime scene reconstruction. I investigated the scene. I tried, I started my 5-step process and really just working closely with the police department to collect as much evidence as we could.
And did you review all the evidence?
Yeah, I did.
Did you create any flowcharts or sheets to help you remember what your theories were?
Yeah, I created a flowchart, a witness tracking spreadsheet, evidence tracking spreadsheet, basically anything and everything I could.
And did these spreadsheets help you come up with your conclusion?
Oh, most definitely, yeah.
Can you tell me what your conclusion of the murder of Mackenzie Brackman was?
I believe it was a burglary gone wrong.
Why do you believe it was a burglary gone wrong?
Well, with all of my experience and training, and the other crime scenes that I've previously investigated, this was nothing special. And as we can see in the ring videos, there was a masked intruder who entered the home of Mr. Brackman uninvited. They weren't armed, so it wouldn't have been necessarily a robbery. And I believe they were surprised by Mr. Brackman when they entered the home.
Do you mind telling me what happened from there?
Well, I believe Mr. Brackman was alerted either by his Ring app or by the intruder opening his back door, obviously. And Mr. Brackman proceeded to arm himself with a knife from his kitchen counter. And there was some kind of struggle between the intruder and Mr. Brackman. Ultimately, the intruder stabbed Mr. Brackman in the back, and Mr. Brackman bled out in his home.
How do you believe the stabbing occurred?
Well, like I said, there was some kind of struggle, and I believe they were in close proximity to each other. And there's no really exact way of knowing, but my working theory, is there was almost a bear hug type of struggle motion where the intruder got the knife into Mr. Brackman's back.
Thank you. No further questions.
Any cross-examination?
Yes, Your Honor. And could I please have a brief time check before we begin?
Yeah, if the timekeepers would go ahead and type in the time check, maybe that's the best way to do it.
Excellent, thank you.
Okay, you can proceed. Thank you.
Yes, Your Honor. Good afternoon, Ms. Kuzak. Let's just get
Hi.
right into it. So referring to the knives you found at the crime scene, let the record reflect that the trial technician will display exhibits 6 and 8. Do you recognize these exhibits?
Yes, I do.
And can you please just tell the jury what these are?
Well, exhibit 6, I believe, is a photo of the knife that was taken at the lab. It's just a general measurement of it. And it is the murder weapon. And then 8, I think it was, it's just a picture of the knife block that was found in Mr. Brackman's home.
Thank you. And you personally observed these things, correct?
Yes, I did.
And these photographs are fair and accurate copies, correct?
It looks like it.
At this time, the defense moves to enter exhibits 6 and 8 into evidence.
Any objection from the people?
Yes, Your Honor. I object to cumulative because a picture of the knife has already been admitted.
And any response from the defense?
Yes, Your Honor. These two images provide a better understanding for the jury as to how the knife itself looks. Exhibit 6 shows a much clearer image with less blood, and Exhibit 8 is completely different from the previously admitted image of the knife.
Your Honor, may I respond?
You may, go ahead.
In Exhibit 6, it shows a picture of the knife, and in a previous witness's testimony, a picture of the knife was already been admitted, and I believe it would waste the jury's time to admit yet another exhibit of the knife.
All right, thank you, counsel. I'm going to overrule this motion at this time. I don't find that Exhibit 6 or Exhibit 8 are cumulative. They will be admitted into evidence and published to the jury.
Yes, Your Honor. Now, Ms. Kuzak, Exhibit 6 shows the murder weapon, correct?
Yes, it does.
And this was a Chicago cutlery knife?
I think so. I can't see that brand on here, but it was when I saw it, yes.
Now, moving to Exhibit 8, that was a J.A. Heckles knife block, correct?
Again, I can't really read the writing on that, but from what I observed at the scene, it was, yes.
And you concluded that the murder weapon came from that knife block, isn't that correct?
Yeah, I did. It was a theory of mine.
But you are aware that these brands don't match.
Yes, I am, but it is still a likely possibility.
Now, moving on, let's talk about the scuff marks at the scene. If the trial technician could please display Exhibit 18. And you believed that these scuff marks, or excuse me, and do you recognize this?
Yes, I do.
And these are the scuff marks at the crime scene, correct?
Yes.
And you observed these as part of your investigation?
Yes, they were a part of it.
And is Exhibit 18 fair and accurate?
Yes.
Thank you. At this time, the defense moves to enter Exhibit 18 into evidence.
Any response or objection from the people?
No objection, Your Honor.
Exhibit 18 is admitted and published to the jury.
Yes, Your Honor. Now, Ms. Kuzak, you used these scuff marks as part of your theory, correct?
Yes, they did play a role in it.
But you have no point of reference as to when these scuff marks appeared, correct?
No, I don't.
You don't have any way of dating them?
That's laughable. No.
Thank you. And you don't have any before or after comparison images?
Why would I?
Okay, thank you. Now, moving on, as to the identity of the perpetrator themselves, you are aware of the ring security videos?
Yes, I am.
And did those show any kind of facial features of the perpetrator?
No, unfortunately, like we've already been over this, they were wearing a mask and gloves and they were fully clothed.
Thank you. And you had no link between the defendant and the clothes worn by the perpetrator?
No.
And there was no DNA of the perpetrator found at the crime scene?
Like I said, they were wearing gloves and a mask, and, contrary to popular belief, you don't leave your DNA wherever you go.
Thank you. And finally, let the record reflect that the trial technician will display Exhibit 17 on the screen. And this is your own report, correct?
Yes, it is.
Thank you. And referring to the first page of this report, the witness tracking sheet, let the record reflect that the trial technician will highlight a portion of text from the top right box under the row labeled Perkins Taylor. And please just read along with me as the trial technician highlights. Provided statement re whereabouts with S1 on day preceding and day of homicide. And did I read that correctly?
I think so, but I didn't see a highlight of it.
My apologies, but those words are included in that box, correct?
Yes, they are.
Objection, Your Honor. Facts not in evidence. Would you like me to explain my objection?
Please, yes.
This exhibit has not been entered in as evidence, and the fact of marking it up before it has been admitted is a violation of Rule 7.3.
Any response from the defense?
I am happy to enter this into evidence, Your Honor. My apologies. I had mistakenly thought that this was previously in evidence from the prosecution.
And Your Honor, I have a small request.
Go ahead.
Under Rule 7.3, exhibits are not allowed to be changed or altered, so I ask that any marking of the exhibits be done after that, after it's been published.
Okay, this is what we're going to do. The objection is going to be sustained, but on different grounds because there was no foundation laid to admit this exhibit into evidence. So the jury is going to be instructed to disregard this as if it was not admitted into evidence. Defense, if you would like, you can certainly lay foundation to try to get this exhibit entered into evidence and then ask questions about it. The last thing I'll say is, since it was not highlighted yet, I'm not worried about that being a violation of any rule, but let's just avoid marking the document at this time to make sure we stay in compliance with everything. So defense, I'll leave it up to you if you want to admit this exhibit into evidence.
Thank you.
Yes, Your Honor. So, Ms. Cusack, you recognize Exhibit 17, correct?
Yes, I do. It's my report.
Thank you. And you regularly make reports and charts such as this, correct?
Most of the time I do use them for a lot of investigations, and I have perfected the technique of making them, yes.
Thank you. And Exhibit 17 is a fair and accurate copy of your work, is that correct?
Yes, it does appear so.
At this time, the defense moves to enter Exhibit 17 into evidence.
Any objection?
There's no objection, Your Honor.
All right, Exhibit 17 is admitted and published, counsel. Thank you.
Yes, Your Honor. Now, at this time, if the trial technician may highlight a portion of text in the top right box.
And counsel, we'll without making a finding on if this is allowed or not, I'm just going to ask that we don't highlight the portion and just have the witness read along, if that's okay.
Yes, Your Honor. So, referring to the same box as earlier, Ms. Cusack, a portion of text reads, provided statement re whereabouts with S1 on day preceding
Objection,
and day.
Your Honor, cumulative under Rule 403.
Is there any response?
Yes, Your Honor. I am reading the text aloud for the sake of clarity of the jury and highlighting portions of Ms. Cusack's report in order to better understand her analysis.
Your Honor, Mayor. Okay.
No, thank you. That's okay. I'm going to overrule the objection and allow you to read that one portion, but please don't go on and read the entire document.
Yes, Your Honor. But I did read that statement correctly, Ms. Cusack.
You read part of it correctly, yeah.
Thank you. And a later portion in the last line of the box reads unlocated party, Blair Rollins. Is that correct?
Yes. Yes, that's correct.
So your own report admits that Taylor Perkins both provided an alibi for Avery Becker and that Blair Rollins remained unlocated.
Yeah, my report does say that.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor, a brief one. Ms. Kuzak, is it your job to find out who committed the crime?
No, my job is crime scene reconstruction.
Is it your job to collect DNA?
Again, no. I simply visit the scene and tell the police department what I think happened.
And lastly, is it your job to look for any facial features or find the race of the intruder?
Again, no.
Thank you. No further questions.
All right, would the people like to call their next witness?
Yes, Your Honor, the people call Alex Cifuentes to the stand.
All right, Alex Cifuentes has already been sworn in. We'll give them a couple minutes to get situated there. And counsel, whenever your witness is ready, you can go ahead and start your examination.
Ms. Cifuentes, are you ready?
Yes, I am.
Please state your name and spell your last for the record.
My name is Alex Fuentes, Sifuentes.
Are you currently enrolled in school, Ms. Cifuentes?
Yeah, I am. I'm a senior at Colorado High School, but we like to call it CHS.
Are you part of any extracurriculars there?
Yeah, I'm on the mock trial team.
Do you know anyone on the mock trial team?
Well, I know everyone on the team, but yeah.
Could you name some specific people?
Yeah, a really close friend of mine, Avery, was on the team, and their friend Taylor as well.
What's Avery's last name?
Becker.
And what's Taylor's last name?
I believe it's Perkins.
Would you recognize Avery Becker if she were here today?
Yes, absolutely.
Your Honor, I now ask that the defendant, Avery Becker, turn on her camera for identification purposes.
Any objection from the defense?
Yes, Your Honor, relevance.
Any response, Ms. Chamberlain?
Your Honor, this is relevant because the witness is just trying to identify that this is Avery Becker.
Yeah, and I do believe that the prosecution has the burden of proof that the defendant committed the crime here. So I'll allow the camera of the defendant to be turned on for identification purposes only.
Ms. Cifuentes, could you point out Miss Avery Becker by a piece of clothing?
Yes, she's wearing a black top.
Is this Avery Becker?
Yes, it is.
Your Honor, let the record reflect that the witness has correctly identified the defendant.
The record will reflect.
Ms. Cifuentes, did you have a coach on the mock trial team?
Yeah, we had such an amazing coach. His name was Mackenzie Brackman.
What was your relationship like with Mr. Brackman?
I loved Mr. Brackman. I thought that he was a fantastic coach, and I really respected him as a coach and as well as a person.
What was your relationship like with Avery Becker?
Avery and I were really good friends, actually. Avery was the one who introduced me to mock trial freshman year, and ever since then we've spent quite a long time in mock trial together.
Did you and Avery ever hang out outside of mock trial?
Yeah, we all. Oh, sorry.
Thank you. I'm sorry. Counsel, Ms. Holland, can you go ahead and restate your objection, please?
Yes, my objection is leading question.
And counsel, I apologize. Can you restate, Ms. Chamberlain, can you restate your last question?
My question was, did you ever spend time with Avery Becker outside of mock trial?
And do you have any response to the objection that that's leading?
Your Honor, this is not a leading question because a leading question implies the answer in the question, and mine did not.
All right. Overruled. I'll allow that question and the witness's answer.
Would you like me to restate my question?
Yes, please. That'd be great.
Did you and Avery ever spend time outside of mock trial together?
Yeah, we all as a team actually went to the Fry Shack and hung out. That was just like the cool place for us all to be. So yeah, we hung out there.
Now, moving on to the night of March 5th, 2020, what were you doing?
I was actually at the Fry Shack with the team, and I did actually spend a little bit of time with Avery and as well as Taylor.
What did you all do there?
We were all just kind of hanging out, honestly. The thing I remember is that Avery actually thanked me for my attempt to help her, and I played some games on Avery's phone as well.
Now, moving back to mock trial, from what you observed being on the mock trial team, how did Avery and Mr. Brackman act towards each other?
Honestly, they were arguing all the time. They constantly disagreed about stuff, and that just brought so much stress onto the team.
Was there any one conflict that stood out to you?
I think the biggest thing that stood out to me was our practice after our regional competition.
What happened during that?
At our regional competition, Avery had won some pretty great awards, and at the next practice, Coach Brackman basically told Avery that she didn't deserve any of the awards, and Avery got super angry and stormed out of practice and wrote Worst Attorney Award on Coach Brackman's car.
Do you know if there were any consequences for Avery?
Yeah, she was kicked off the team permanently.
Do you know if Avery ever tried to get back on the team?
Yeah, actually, she reached out to me.
What did she say?
She asked if I was willing to talk to Coach Brackman on her behalf about being let back on the team.
Did you try to help Avery get back on the team?
Yeah, I told her that I was willing to do that, and so I did.
Did Coach Brackman let Avery back on the team?
No, he was still very upset about everything that had happened, so he was not willing to.
Did you tell Avery this?
Yeah, I did, and she didn't react super well to that.
How do you know that she didn't react well?
She said that if Coach Brackman was upset about what happened to his car. I'm sorry, I heard an objection.
Yes, I object to the grounds of hearsay.
Oh, I apologize, counsel. I didn't hear that. The objection was hearsay. Any response from the people?
Your Honor, this is not hearsay because of the party opponent rule.
And any reply from the defense?
I stand by my objection, Your Honor.
All right, the objection at this time is overruled. You can proceed.
Could you please re-ask your question?
How did you know that Avery didn't react well?
Because she said to me that if Coach Brackman was upset about what happened to his car, then he should see what was going to happen to his house.
Did Avery ever tell you what she was going to do to Mr. Brackman's house?
Yeah, she said that she was going to break in while he was at work and trash the place.
Did Avery Becker ever communicate with you again after this?
Not that I believe.
Thank you, Your Honor. No further questions.
All right, counsel, any cross-examination?
Yes, Your Honor.
You can proceed.
All right, good afternoon, Ms. Cifuentes. Let's start by talking about Ms. Becker. You knew Avery Becker from your high school mock trial team, yes?
Yes, that's correct.
You were teammates for 3 years?
Yes.
You were a hardworking member in mock trial, correct?
I'd say I was, yeah.
And you took it very seriously, yes?
I did. It was something that was very important to me.
You don't think that Avery works very hard in mock trial, do you?
Not from what I saw, no.
Avery was rarely prepared?
Correct.
Yet, Avery frequently received awards, didn't she?
Yes, she did.
And this bothered you, yes?
Yeah, it was definitely frustrating for me.
And Avery was kicked off of the team by Mr. Brackman, yes?
Correct.
It opened up an opportunity for you to get a larger role on the team, correct?
I didn't really know what Coach Brackman's plans were, but that makes sense, yes.
Repeating the question with, if you could please provide a yes or no answer, it opened up an opportunity for you to get a larger role on the team, yes?
I'm not sure, but I believe so, yes.
And you were glad that Avery was kicked off of the team, yes?
Honestly, yeah, I thought the team was better off without her.
Avery texted you to speak to the coach on her behalf. Is this correct?
Yes.
But you do not have these original texts with you?
I actually don't have the phone that I had when this conversation occurred anymore, so no.
And you never showed these texts to law enforcement, correct?
I actually offered to, but they didn't need it. They said that I could just send screenshots, so I did.
You also never, so to establish this, you never showed these texts to law enforcement, correct?
I sent them
Objection.
screenshots.
Ms. Chamberlain, can you restate your objection, please?
Facts not in evidence.
And can you go ahead and explain the objection?
These text messages that opposing counsel is talking about have not been admitted into evidence.
And any reply from the defense?
Your Honor, I'm simply clarifying that these texts were not sent to law enforcement. Therefore, they wouldn't need to be in evidence.
On those grounds and for that limited purpose, Ms. Holland, I'm going to allow the question, so the objection is overruled. Ms. Chamberlain, if you think she starts to stray from that, though, please feel free to renew your objection.
These texts were never given to law enforcement, yes?
Well, the screenshots were, yeah.
But the original texts were not?
Correct.
Speaking of phones, Avery let you play a game on her phone at the Fry Shack the night before the murder, yes?
Yes, she did.
So you were in possession of the phone the night before the murder?
At some point, yes, just to play games.
And this was the same night before Avery lost her phone, yes?
That's correct, I believe, yeah.
At this time, no further questions, Your Honor.
All right, any redirect from the people?
No, Your Honor.
All right, and may this witness be excused? I believe that's a yes. I don't think we can recall witnesses anyway. Are there any further witnesses that the people or prosecution would like to call?
No, Your Honor.
And so does that mean the people rest at this time?
Yes, Your Honor.
All right, are there any halftime motions by the defense?
No, Your Honor.
Okay. Since there are no motions, we can proceed with the defense's case in chief if they decide to put on evidence. Before we do, I just want to just note for the scoring panelists that we did clarify that a document, once it's admitted, can be changed on Zoom. So please keep that in mind. I wanted to avoid making an actual ruling on whether that was allowed or not. So let's just make sure we don't dock anyone, because that is not a rule. I just wanted to clarify that. And with that, would the defense like to call their first witness?
Yes, Your Honor. At this time, the defense calls Professor Blake Van Owen to the stand.
All right, counsel, and once you're set up, you can proceed. Let's actually give 1 second for the people to get on here in case they want to or need to object.
Yes, Your Honor.
Ms. Thompson, are you ready to go in case you need to object?
Yes, I am. I'm just having a little bit of camera troubles.
Okay, that's okay. Let us know if you need us to stop if you're not able to hear anything. Ms. Hilden, you can start your direct examination.
Yes, Your Honor. Thank you. Good afternoon, Professor Van Owen. Can you please state your full name and spell your last for the court?
Good afternoon. My name is Blake Van Owen, V-A-N-O-W-E-N.
Thank you. And what is your profession?
I am a private investigator, a professor, and an expert witness in police practices.
Can you please tell us about your experience with law enforcement?
I have worked at the Aurora Police Department. I worked as a school resource officer, then a private security guard, and then I went into private investigation.
Thank you. And do you have any other experience in police procedures?
Yes. I have a master's degree in criminal justice through Ashford University. I also taught a class on police procedures at the Community College of the Rockies and a class on police practices and social justice at CU Denver.
And have you ever testified in court before?
Absolutely. I regularly testify as an expert witness in many fields, such as police practices, use of force, false arrest, forensic evidence techniques, crime scene reconstruction, cell tower analysis, and police investigation tactics.
Thank you. And what courts have accepted you as an expert witness?
I have been accepted as a defense expert in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and in the state district courts of Colorado, Wyoming, Nebraska, and New Mexico.
Thank you. And do you have any other pertinent experience related to court cases?
Yes, I have been accepted as an expert in crime scene reconstruction 8 times, in cell tower analysis 5 times, and in general police investigation tactics 12 times. I have consulted on over 100 cases.
Your Honor, at this time, the defense moves to enter Blake Van Owen as an expert in police practices, cell phone tower analysis, and crime scene reconstruction.
Sorry for the delay there, counsel. I wanted to make sure I was noting the fields of expertise. Are there any objections from the prosecution?
Yes, Your Honor. May I perform a brief voir dire?
You may.
Ms. Van Owen, you haven't testified to any education you've had in crime scene reconstruction?
I've been accepted as an expert in 8 crime scene reconstruction cases.
But Ms. Van Owen, you haven't testified to any formal education that you've had in crime scene reconstruction?
Well, I've taught a class on police procedures and a class on police practices and social justice.
Ms. Van Owen, I think you misunderstood my question. You have not had any formal education in crime scene reconstruction.
Not formally, but I've been a police officer.
But again, that was a no, you haven't had any formal education.
I don't have a degree in crime scene reconstruction, no.
And do you teach a class on police practices?
Yes.
And you haven't been a police officer for 8 years?
Well, I worked as a school resource officer, which is technically in the police department.
But you haven't been a formal police officer in 8 years, is that correct?
No, but I teach a class on police procedures, which I believe keeps me up to date on their policies.
But Ms. Van Owen, that was a no, just to clarify?
No, that was a no.
And you were only a police officer for 10 months?
Yes, after I was...
Just to clarify, you were a police officer for 10 months?
Yes.
You wrote an affidavit in this case?
Yes, I did.
And in that you put all relevant and true facts?
Yes.
Your Honor, I am now asking my co-counsel to screen share Blake Van Owen's affidavit. And I am so sorry for the delay.
Oh, no, that's okay. Sorry, if you're asking permission, it's approved. If we're just waiting, that's okay as well.
And can I ask that time be stopped while we deal with this technical issue? Thank you. Ms. Van Owen, in your affidavit, you state that you were a police officer for only 9 months. Is that correct?
Yes, I was. At the Aurora Police Department.
Thank you. I will ask co-counsel to stop screen sharing at this time. So you haven't had any new training educating you on the new tactics of the police department?
I teach a class on the police practices, so that keeps me up to date on their policies.
But you haven't had any new training to be updated in police practices?
Not as an officer, but as an educator, yes.
You've had new training in police tactics?
Not as an officer, but as an educator.
And again, you weren't a police officer, you haven't been a police officer for 8 years.
I've been a
Objection, Your Honor.
Ms. Hilden, what's your objection? What are the grounds?
Asked and answered. Professor Van Owen has already testified to her experience in the police department and previously discussed the amount of time spent there as well as her training afterwards. Or excuse me, not training, but work experience afterwards.
Any response?
Yes, Your Honor. I was just asking a clarifying question to aid the jury's understanding.
I will overrule the objection at this point, but counsel, I will ask that you wrap up the questioning relatively soon, and if you have any objections as to this witness's qualifications, to then raise them.
Yes, I am done with my voir dire. I do object to crime scene reconstruction and police practices.
And any response from the defense?
Yes, Your Honor. Professor Van Owen has demonstrated through both her degree in criminal justice as well as teaching courses on social justice and police procedures that she has the relevant knowledge in these fields, as well as having been consulted on over 100 cases, all of which would have involved these methods of investigation.
Your Honor.
You can reply. That's okay. Go ahead.
Sorry, I didn't mean to interrupt. Although co-counsel has responded to the police practices objection, they haven't responded to the crime scene reconstruction objection. And to clarify, Miss Van Owen, again, has said that she hasn't been a police officer for 8 years and hasn't been trained as one for 8 years. So she isn't up to date on the new police practices that she would be testifying on.
Response, Your Honor?
Last word. Go ahead, Ms. Holden.
Yes, Your Honor. In terms of opposing counsel's claim that Professor Van Owen isn't up to date on modern police procedures, as Professor Van Owen is currently teaching a course on them, she would be aware of the current policies.
This time the court is going to overrule the objection and say that the points raised by Ms. Thompson are certainly ripe for cross-examination, but this witness is recognized as an expert in police practices, cell phone tower analysis, our forensics, and crime scene reconstruction. Counsel, you can proceed with your questioning.
Thank you, Your Honor. Now, Professor, let's move on to the investigation. What can you say about the quality of the police department's work?
After reviewing all of the police reports, the crime scene reconstruction, the cell tower reports, and exhibits prepared by Detective Markowitz, and conducting my own partial investigation, I can tell you that the work the police department did was sloppy.
And what makes you say that?
Kyle Kuzak was obviously investigating with the suspect in mind.
And what makes you believe this?
Kuzak's investigation was blind to evidence that supported other, even more likely theories. Kuzak even pulled pieces of narrative out of the blue with no evidence, such as that the intruder stabbed Mr. Brackman with the same knife that he had retrieved from a knife block in the kitchen, just to make her story more coherent.
Now, allow me to direct you to Exhibit 20 at this time and let the record reflect that the trial technician will screen share it. Do you recognize this?
Yes.
And what is Exhibit 20?
This is my official report analyzing the investigation done for today's case.
How do you recognize this?
I made this myself.
And is this a fair and accurate copy of your work?
Yes.
And when you testify, do you regularly make reports such as this?
Absolutely. It's part of being an expert witness.
At this time, the defense moves to enter Exhibit 20 into evidence.
Any objection?
Yes, Your Honor, I object on the grounds of hearsay.
And any response from the defense?
Yes, Your Honor. This is accepted under the rule of hearsay, under Rule 8036 being a regularly conducted business activity, as Professor Van Owen has just testified to.
And any reply from the people?
Yes, Your Honor. Although this is a regularly conducted business activity, we have seen no other proof that Miss Van Owen does this in her other cases, as well as this being cumulative because we already have the reports from the other experts.
Counsel, at this time, I'm going to sustain the objection. I do believe that this is hearsay, and I'm going to ask that the witness, of course, can certainly testify about all of her findings that may be contained in this report, but I want to make sure that that testimony comes out live as opposed to through hearsay.
Yes, Your Honor. Now, Professor, what did you believe occurred during the events which we are discussing today?
I believe that, in my expert opinion, Mr. Brackman was sitting, and the intruder behind him stabbed him, holding the knife, as one did in the movie Psycho. If Brackman were standing, the intruder would have had to be much bigger than him, which we can rule out from the ring video evidence.
Now, can you please tell us more about those ring videos you just mentioned?
Yes. I also have a ring security setup in my house, and I am aware of its pitfalls, though Detective Markowitz makes a big deal out of the ring alerts. A user can turn off push notifications, allowing an intruder to break in without the victim ever being aware. Markowitz did not collect records from Ring to check whether Brackman had its notifications on. And even if he did, Brackman might not have had his phone on him or been paying attention to it, and he still would have been surprised by the intruder. Cusack just jumped to conclusions that the alerts were on.
Now, let's move on. What can you tell us about Avery Becker's cell phone?
The investigators used cell phone tower data to locate the phone, despite Avery Becker having been separated from the phone the entire night before.
And can you please tell the jury more about how cell phone tower data works?
Yes. Cell tower data is much less accurate than GPS data. Since we don't have the actual phone and we have to rely on cell tower data, we can never know if the phone was ever close to the victim's home. Each cell tower can reach up to 6 miles radius in each direction.
Thank you. And in this case specifically, how was cell tower data investigated?
Detective Markowitz only subpoenaed the cell tower records for a limited window of time, so we can only know that the phone connected with a cell tower somewhere in the area. There is no way to tell that Becker's phone made it from Becker's house to Brackman's house just before the murder.
Now, moving on, can you please tell us about how phones were otherwise considered in this case?
Well, since the prosecution only had one suspect in mind from the beginning, only cell data from Avery Becker's phone was looked at. A smarter thing to do would have been to obtain cell records from all of the phones in the area and talk to anyone who had a connection with the witness or the victim. Especially important was Taylor Perkins' phone, considering that Becker was with Perkins the entire day of the murder.
Now, moving on from that, what can you tell us about the text screenshots provided by Alex Cifuentes?
The screenshots of the messages sent to the police by Alex Cifuentes were not questioned in the slightest. It is the job of the police to be skeptical. The Denver Police Department has the tools to run examinations on cell phones that could have verified or falsified this evidence, but they literally chose not to do the work.
And finally, could you find any other possible suspects in your investigation of this case?
Yes, Blair Rollins is a much more likely suspect.
And why do you believe this?
Blair's father, Jonathan Rollins, was defended by Mackenzie Brackman in a court case and was put away for life for being convicted of murder.
And so, did you investigate the court case of Jonathan Rollins in your investigation?
Yes.
In preparation for testimony today, have you listened to what has been marked as Exhibit 22?
Yes.
And as far as you are aware, has this audio clip been available to the prosecution?
Yes.
And are you aware under the circumstances which the audio clip was created?
Objection, Your Honor. Leading question.
Response?
I don't believe this question implied the answer within it, Your Honor. I was simply asking if Professor Van Owen is aware where this audio clip came from.
Overruled. You can answer the question.
Would you like me to repeat my question, Professor?
Yes, please.
Are you aware how or where this piece of audio came from?
Yes. This was after John Rollins had been convicted. He shouted this out in court.
Thank you. And as far as you are aware, is the audio clip fair and accurate to what was heard in the court the day of the trial?
Yes.
At this time, the defense moves to
Objection, Your Honor. Lack of foundation. Would you like me to explain my objection?
Not quite, Ms. Thompson. Ms. Hilden, for the record, I'm going to go ahead and ask that you finish saying what you were seeking from the court. Can you go ahead and finish what you were saying?
Yes, Your Honor. At this time, the defense moves to enter Exhibit 22 into evidence so that it can be played for the jury.
Okay, and the objection from the prosecution is what?
Lack of foundation, as Miss Van Owen has not testified to being in court the day that he was sentenced. She has no way of knowing if this was the same as it was before. Also, we have not seen the recording yet today for Miss Van Owen to see if it is a clear and accurate representation of what she heard previously.
And what's your response?
Well, as far as the audio having not yet been played, that is for the sake of ensuring that the jury does not hear evidence before it is actually admitted. And in terms of Professor Van Owen's sense of where this audio came from, part of her investigation was the court case of Jonathan Rollins, and she would be aware as to pieces of evidence pertaining to this trial that came from that one.
I'm not concerned about the fact that this hasn't been played yet, because the witness did testify that this was reviewed prior to testifying in court. My concern, counsel, is we don't know yet how this recording was obtained or how this witness can authenticate this is in fact said by this individual. Can you explain a little bit more of that to me?
Yes, Your Honor. Given the context of the rest of the trial, Professor Van Owen highlighted the portion of audio which is part of the evidence, but that came from that would have been recognizable given what she likely heard in the rest of the trial's recordings.
Your Honor, may I respond?
I'm sorry, at this time I'm actually going to overrule the objection. Thank you. I'm again going to say it's certainly right for cross-examination, but counsel, you can go ahead and play the recording.
Yes, Your Honor. Let the record reflect that at this time, the trial technician will play Exhibit 22 for the jury.
I'll get you back, Brackman, if it's the last thing I do.
Now, Professor, did this audio clip play any kind of role in your investigation?
Yes. Blair Rowland's father was not only sent to life in prison, but he threatened the victim whose murder is being investigated today.
So, given your expert opinion, how do you view the work done on today's investigation?
There were so many errors on the prosecution's end. Not only did they investigate already considering Avery Becker guilty, but they failed to obtain relevant cell tower records. They lost pictures of blood drops in the hallway, and the mysterious digital files were corrupted. Any halfway decent police department would have kept more than one copy of digital photos from a murder investigation. I don't suspect malice. I understand it was incompetence.
Thank you, Your Honor. No further questions at this time.
Any cross-examination?
Yes, Your Honor. Good afternoon, Miss Van Owen. We're going to talk a little bit about your work experience first. So you were a police officer for 9 months?
Yes.
And you later quit that job?
Yes, after a scuffle with a woman, I realized that the police department's ethics were all out of sorts, and I did not
But
want
just
to
to clarify, Miss Van Owen, you did quit this job?
Yes, absolutely. I was not going to be associated with the police department after that.
And after you couldn't make it as a police officer, you decided to be a mall cop?
It wasn't that I couldn't make it as a police officer. I decided to quit the force because my moral code didn't line up with theirs. And then I decided to be a school resource officer.
And after that, you decided to be a mall cop?
I don't see what that has to do with today's case.
The question was, and after that, you decided to be a mall cop?
Yes.
You said that you didn't agree with the police practices in the way that how you explained the scuffle was handled. So you're here today testifying against the police practices that were used.
Yes, I believe that Detective Markowitz and Kyle Kuzak greatly misunderstood and mishandled this case.
And just to clarify, you quit your job because you didn't agree with the police practices?
Yes, there are
And
so
you're
many.
here today and you're here today testifying against police practices?
Objection, Your Honor. Asked and answered.
Any response?
Yes, I'm just asking a clarifying question. Ms. Van Owen continues to go on rather than answering with a yes or no, so I just want to clarify to aid the jury's understanding.
Overruled. You can answer the question.
Ms. Van Owen, after you realized that you didn't want to be a part of police practices because you didn't agree with them, morally, you decided to, you're here today testifying against police practices. Is that correct?
I am here testifying, trying to prove Avery Becker guilty because I believe that she is. I know that she is.
And you're trying to prove that through what you believe to be faulty police work.
Well, there is evidence in the faulty police work, yes.
And you're not currently a police officer, is that correct?
No, I'm currently teaching a class on police practices.
We're going to talk a little bit about your partial investigation. Just to clarify, you only performed a partial investigation?
Yes, it's not my job to complete a full investigation.
And we're going to move back to what you said previously. You said it was your job here to prove Avery as guilty.
Innocent.
Those were your words? Okay. So we're going to move back to your partial investigation. So through your partial investigation, you decided that the two experts that performed their investigation, that their work wasn't adequate.
Yes, that is true.
And you know Kyle Kuzak professionally, don't you?
I do, and I don't mind her as a person.
But you believe they're egotistical.
Objection, Your Honor. Relevance and speculation.
Response?
Your Honor, this is relevant because it's showing any bias that Ms. Van Owen has towards Kyle Kuzak because she is testifying what she believes to be what was done wrong in his investigation. And towards the speculation, she has the opportunity to agree with what I'm saying or disagree.
I agree that it goes to the witness's credibility, so I'm going to overrule the objection at this time.
Ms. Van Owen, you believe that Kyle Kuzak is egotistical.
I generally like Ms. Kuzak, and we all have our shortcomings. Yes, I believe.
But you do believe that they're egotistical.
Yes, but that doesn't make me dislike her as a person.
We're going to talk a little bit about Blair Rollins. You believe Blair Rollins is a suspect in today's case?
Absolutely. Much more likely than Avery Becker.
And you had an interview with Blair Rollins, is that correct?
No, Blair Rollins disappeared after graduation and is nowhere to be found.
So you were unable to have an interview with your key suspect?
So is the prosecution. It's not my burden of proof to find Blair
Rollins.
But
again, you never had an interview with your key suspect.
It's not my burden of proof, it's the prosecution's.
So I'm asking for a yes or a no answer. You never had an interview with your key suspect?
No, Blair is nowhere to be found.
But you did try and find Blair, is that correct?
Yes, but no one can find Blair.
And you use Google to try and find Blair?
Yes, I tried, but she's disappeared.
And you were unable to find out where your key suspect was on the day of March 6th, the murder?
Yes, and Kyle Kuzak has also investigated Blair Rollins and believes that she is a suspect and has not been able to find Blair.
But again, Ms. Van Owen, you were not able to find out where your key suspect was on the day of the murder.
It's not my burden of proof, it's the prosecution's burden of proof.
But again, just a yes or a no answer, you were unable to find out where Blair was on the day of March 6th.
It's not my job to find out where Blair was on the day of March 6th.
Objection, Your Honor. I object to non-responsive. Ms. Van Owen is not answering with a yes or a no in this question.
Response, Your Honor.
You can respond.
Your Honor, Professor Van Owen has been answering these questions, and even if they are not a single yes or no answer, she has been providing fairly clear answers to these questions.
At this time, I don't believe we've heard a yes or no on whether this individual was found or located on the date of the crime in question. So I am going to ask the witness to just give a yes or no answer on that particular question.
Thank you. May I continue?
You may.
Ms. Van Owen, just to clarify, you were unable to find out where your key suspect was on the day of March 6th, the murder.
Yes.
We're going to talk a little bit more about Blair. You believe Blair has motive?
Absolutely. A much bigger motive than Avery Becker.
But you were unable to even find Blair Rollins' phone records on the day of March 6th.
It's not my job to find Blair Rollins' phone records. It's the prosecution's
But you
burden.
didn't particularly find where your key suspect's phone records were on March 6th.
It's not my job to find where Blair's phone records were. It's the prosecution's burden.
Again, Ms. Van Owen, I would ask that you answer this question in particular with a yes or no. You were unable to find out where Blair Rollins' phone records were on the day of March 6th.
It's not as simple as a yes or no, counsel.
Ms. Van Owen, it's a simple yes or no answer. You were unable to find Blair Rollins' phone records on March 6th.
Yes.
Thank you. And you mentioned previously that you believe Kyle Kuzak did an investigation with Blair.
I believe that Kyle Kuzak admitted that Blair was a suspect, but failed to commit a proper investigation.
But again, you aren't aware whether or not Blair, if Blair Rollins was investigated by Ms. Kuzak.
Well, since Blair disappeared, and no cell phone records or anything has been found for Blair, and Avery Becker is standing here on trial, I know that a proper investigation was not conducted for Blair Rollins.
And you weren't able to conduct a proper investigation either, is that correct?
Again, counsel, it's not my job to conduct an investigation. It's the prosecution's burden.
But just to clarify for the jury, you were unable to perform a proper investigation as well.
Yes.
Thank you. No further questions.
Any redirect?
Yes, Your Honor, briefly. So as far as your work with the police force, Professor, why were you personally against their morals?
Well, after I got into a little scuffle with a woman of color, she sued me and the police department. And after hurting her, I realized that even though my methods were accepted by the police, I felt so guilty and I never wanted to be in that position again. And I didn't agree with the way the police handled itself.
Thank you. And as far as the investigation into Blair Rollins, was anybody able to find Blair for an interview?
Nope, nobody.
And as far as your own investigation in believing that Blair was a suspect, did you still have a proper lead as to believe that?
Yes, there is sufficient evidence to believe that Blair is a suspect.
Thank you, Your Honor. No further questions.
All right. Would the defense like to call their next witness?
Yes, Your Honor. The defense calls Ms. Taylor Perkins to the stand.
All right, and let's give the prosecution just 1 second to get their counsel on the screen for objections. All right, it looks like Ms. Klausner's on. So counsel, Ms. Holland, you can start your direct examination whenever you're ready.
Yes, Your Honor. Good afternoon, Ms. Perkins. Could you please state your name and spell your last for the record?
Sure thing. Taylor Perkins, Perkins.
Now, Ms. Perkins, tell us a bit about yourself.
Sure thing. I'm a freshman at CU Boulder this year, which is a lot of fun. I graduated from Colorado High School last year, and I was in a plethora of clubs in high school, including mock trial.
And did you have friends in mock trial?
Yes, I was in mock trial with my very best friend, Avery Becker, which was a lot of fun. I enjoyed mock trial because of Avery.
Who is Avery Becker?
Counsel, and I apologize. I'm sorry to interrupt. Ms. Klausner, I just wanted to make sure you can hear the direct examination.
I can. The camera's just very delayed.
That's okay if it's delayed. And Ms. Holland, I'm sorry. I just wanted to make sure we were all present. You can continue.
Thank you, Your Honor. Tell us more about Avery Becker.
Yes, Avery was my best friend. We were on mock trial together. Avery was the best attorney on mock trial, no doubt about that. Avery did not have to put in a lot of work to succeed. Avery was just naturally talented, which definitely bugged some people, including our coach and other people on the team.
Could you tell us more about this coach?
Yeah, Coach Brockman was a great guy. It's really sad to think that he's not with us anymore. Coach definitely pushed Avery, considering that she was naturally talented, and Avery and Coach Brockman did not always get along because of that. They had somewhat of a feud, which in my opinion was just childish and funny.
Can you tell us more about this feud?
Yeah, sure thing. So right before the regional competition, Coach Brockman demoted Avery onto the B team because he said that Avery was unprepared and not ready for the regional competition, which in my opinion was just unfair. Avery had worked.
Objection, hearsay.
And Ms. Klausner, can you clarify which statement in particular you're stating is hearsay?
Just that Mr. Brackman was stating specific things before the competition.
Any response from the defense?
Your Honor, I believe I've laid the proper foundation that Ms. Perkins was in mock trial with her coach and her teammates and would have the knowledge of her coach.
And can you give me just an offer of proof of what sort of statements you think Ms. Perkins is going to testify about?
When I asked to tell about, excuse me, when Avery was demoted from the A team to the B team, that is all that I am looking for.
Okay, so no particular statements?
No, not in particular.
Okay, overruled at this time.
All right, may I continue?
You may.
So Miss Perkins, after Avery was demoted from the A team to the B team, what did you do?
I stepped down in honor of Avery, being that Avery was the best lawyer on the team and Avery was my best friend. I felt as though that was the right decision.
And was this a big sacrifice for you?
No, mock trial was more of a social aspect for me, which quite honestly, I felt like that was the right decision, being that Avery was my best friend and Avery was good at mock trial. And my thought proved correct because Avery won best closing and best attorney at regionals.
And were there any other examples of this feud between Avery and her coach?
Yes, Avery took what she believed to be a dry erase marker and wrote on Coach Brockman's car, worst attorney award, and it ended up being a permanent marker, which caused Coach Brockman to kick Avery off the team permanently.
And what happened after that?
After that, it was kind of unfair, in my opinion, that Avery was kicked off, but we all kind of blew it off because state was canceled due to COVID.
And backtracking to Avery's attempts to get back on the team, how did that play out?
Yeah, Avery texted a bunch of team members on the team, texting them, trying to see what their thoughts were with Coach Brockman. Avery also texted Alex Fuentes, which was a surprise to me because Alex and Avery were not friends. After that, Avery went to Coach Brockman's practice and tried to appeal to Coach, but it didn't work out too well. And so me and Avery went to the mall to try and blow off some steam. And along with that, we went to the Fry Shack, just kind of hanging out. And Avery ended up losing her phone that day.
You say that Avery lost their phone. What did you guys do about that?
Yeah, so we only realized until the next day that Avery had lost her phone. So we went back to the mall, to the Fry Shack, trying to retrace Avery's steps and find the phone and calling it, which had no luck. So we just ended up hanging out at the Fry Shack and hanging out there looking for the phone.
Did you see anyone that you knew at the Fry Shack?
Yeah, it was kind of weird. We saw some other team members that day at the Fry Shack, which was quite bizarre because we knew they were supposed to be at practice and they said that Coach Brackman never showed up, which I guess now we know why.
And was there anyone else gone from school that day?
So the day that we skipped school to go and look for Avery's phone, there was also a kid named Blair Rollins that was missing from school. Kind of a weird kid and friends with Alex, but that's all I know.
Thank you, Your Honor. No further questions.
Any cross-examination?
Yes, Your Honor. You were best friends with Avery Becker, weren't you?
Yes, Avery was my best friend.
You were on the mock trial team with Avery, weren't you?
Yes, I was.
You thought Avery was the best on the team, didn't you?
Avery definitely was the best on the team, correct?
You thought that Mr. Brackman was mediocre, though, didn't you?
Mr. Brackman at times was mediocre, in my opinion, correct?
From what you observed, it seemed that Avery felt the same way, didn't she?
Yeah, Avery and Coach Brackman did not always get along.
Avery played a lot of pranks on Mr. Brackman, didn't she?
I wouldn't necessarily call them pranks.
Avery eventually was demoted from the A team to the B team, wasn't she?
That's correct. After Avery was unprepared for the regional tournament, Coach Brackman demoted her.
Well, after regional competition, Avery was kicked off the team permanently, wasn't she?
Avery was kicked off the team after she wrote on Coach Brackman's car.
Avery tried to apologize to Mr. Brackman several times. Is that right?
Multiple times, yes. She felt very sorry for the actions that she had done.
On March 5th, you and Avery went to the Fry Shack after a failed attempt at apologizing to Mr. Brackman, didn't you?
Yes, after Coach Brackman did not accept Avery's apology at practice, we did go to the Fry Shack.
When you were there, you saw the whole mock trial team. Is that right?
That is correct.
Alex Cifuentes was at the Fry Shack as well, right?
That is correct.
Alex and Avery didn't particularly get along that night, did they?
They weren't the best of friends, but I wouldn't say that they didn't get along all the time.
Avery got so upset that she had to take a break to go to the bathroom, didn't she?
That's true. Avery was upset and did go to the bathroom.
You two left when Avery came back, didn't you?
That's correct.
When the two of you left, you didn't see if Avery picked up her phone or not. Is that correct?
That is correct. I'm not always paying attention to other people's belongings.
And it wasn't until the next day that you saw Avery again, right?
That is correct.
Avery came to pick you up from your house for school, right?
That is correct. We had a routine and it was just standard that Avery would do that.
When she came to pick you up, you mentioned that she hadn't answered any of your texts that morning, right?
That is correct.
Then the two of you decided to ditch school to go look for the phone, right?
That is correct. Being seniors, we don't have a ton of classes and decided that we just wanted to take the day off and go look for her phone.
You decided this sometime in the morning, right?
To go and look for Avery's phone?
Yes, you decided to look for the phone in the morning.
Yes, that's correct.
You went to the mall first, right?
That is correct. That was one of the places we had gone the day prior.
Then you went to the Fry Shack after that, correct?
That is correct, after we had no luck of finding Avery's phone at the mall.
You then again went back to the Fry Shack in the afternoon to check with the next staff shift, right?
Objection, Your Honor, relevance.
Response?
Your Honor, I believe that the claimed whereabouts of Avery and Taylor are very relevant to this case, especially on the date of March 6th.
Overruled. You can re-ask the question.
You later went back to the Fry Shack in the afternoon to check with the next staff shift, didn't you?
Yes, we were looking for Avery's phone in different areas, and we figured if one shift did not have it, the other might.
You burned through the whole school day looking for the phone, right?
That is correct. We had no luck.
You spent this time with Avery because you're her best friend, right?
Avery's my best friend, and like you said, and I do enjoy spending time with her no matter what we're doing, whether that's looking for a phone or being on mock trial.
Thank you. No further questions.
Any redirect?
Yes, Your Honor, briefly. Ms. Perkins, what were you two doing the day of the murder?
The day of the murder, we were off at the mall, hanging out, trying to blow off some steam after Avery had been kicked off the team.
And why wasn't she answering her texts the morning of the murder?
Avery said that she didn't have her phone.
Does your opinion of Coach Brackman matter in this case?
No, Coach Brackman was a good person, and I think that Avery felt the same way. It really was just a good coach to have around.
And finally, Ms. Perkins, in light of the incident with Mr. Brackman's car, why did you remain friends with Avery?
Avery tried really hard to get back on the team and apologize to Coach Brackman. She felt very bad, and she said that it was an honest mistake. And being that, although Avery committed vandalism, Avery's not capable of murder.
Thank you, Your Honor. No further questions.
The defense like to call their next witness.
Your Honor, at this time, the defense calls Avery Becker to the stand.
All right. I believe we have everyone present. You can proceed.
Ms. Becker, please state your name and spell your last for the record.
My name is Avery Becker, spelled Becker.
Why are you in court today, Ms. Becker?
I'm today here in court because I'm being wrongly accused of murdering my former coach, Mackenzie Brockman.
And could you be a little bit more specific about who Mackenzie Brackman was to you?
Of course, Mackenzie Brockman was my former coach on the CHS mock trial team for the 4 years that I was a part of the program.
What was your relationship like with Mr. Brackman?
Although I did respect his ability to get the team to a competitive level, Mr. Brockman and I did not get along very well, and we did butt heads on a few occasions.
How did Mr. Brackman criticize your work ethic?
Well, he did not like my work ethic because I was quite naturally talented in mock trial and therefore did not have to work as hard as other people. And to answer your question, he criticized my work with hurtful and humiliating comments, and also by demoting me from the A team to the B team on mock trial.
Now, Ms. Becker, can you please describe this demotion in a little bit more detail?
Yes, so I came to practice just like any other day. And as soon as I got there, Mr. Brockman seemed quite upset with me based on the words and also his facial expressions, and started saying that I was unprepared and didn't deserve to be on the A team, so he demoted me to the B team.
Now, Ms. Becker, how did you make it back onto the A team?
Well, my best friend, Taylor Perkins, took it upon herself to step down from the A team on mock trial. And as a result of that, I was reinstated on the A team just before the regional mock trial tournament.
Ms. Becker, how did you perform at the regional tournament?
Just as well as I hoped. I received the Best Attorney Award and was named Best Closer.
How did Mr. Brackman react to these accomplishments?
Well, my expectation would have been that he would have been proud of my accomplishments and even complimented me. However, this was not the case. In fact, he told me I did not deserve these awards and simply relied on my good looks to receive them.
Now, Ms. Becker, how did you react to Mr. Brackman's comments?
Well, I was quite hurt by these comments and frankly a little bit insulted because I did earn these titles.
And what happened after Mr. Brackman made these comments?
I did one of the stupidest things I've ever done in my entire life. I stormed out of practice with what I thought was a dry erase marker in my hand and wrote across the hood of his Porsche, "Worst Attorney Award."
How did Mr. Brackman react when he saw this?
Well, understandably, he was very upset and he kicked me off the team immediately, which I absolutely deserved.
Now, Ms. Becker, how did you feel after this incident?
I felt horrible. I tried to apologize to Mr. Brockman on multiple occasions, including going in person to his office to try and apologize face to face, texting him, and asking other team members to apologize on my behalf when he was not responsive to any of these other methods.
Now, moving on to March 6th, the day of Mackenzie Brackman's death, where were you on March 6th?
I was with my best friend, Taylor Perkins, the entire day searching for my lost phone.
What had happened to your phone?
Well, the day before, when I was at the Fry Shack, I lost my phone.
Ms. Becker, where did you last see your phone?
The last time I can vividly remember seeing my phone is on a table at the Fry Shack, and at that table, Alex Cifuentes was sitting and playing on my phone.
So just to clarify, Ms. Becker, you were not at Mr. Brackman's home on March 6th, 2020?
Absolutely not. There is no way I could have been at his house, seeing as I did not even know where he lived before this case.
And Ms. Becker, do you know Blair Rollins?
Yes, I do. Blair Rollins is a person who goes to my school, or my former school, CHS.
And what is Blair Rollins' connection with Mr. Brackman?
Well, Blair Rollins, according to my knowledge of a pretty public case that occurred, is the daughter of a man who was sent to prison for murder after he was defended by Mackenzie Brackman.
And how would you describe Blair Rollins physically?
Blair Rollins and I have very similar height and builds, and we are often mistaken for each other at school.
And where is Blair Rollins now?
I have no idea where Blair Rollins is, nor do I, as to my knowledge, think that anybody knows where Blair is.
Now, finally, Ms. Becker, did you kill Coach Brackman?
Absolutely not.
Thank you, Your Honor. No further questions.
Cross-examination.
Could I get a brief time check before I start my cross-examination?
There's 4 minutes and 18 seconds left for cross.
Thank you. May I begin?
You can. Thank you.
Miss Becker, you were really good at mock trial, correct?
Yes, I was.
But not everyone appreciated this talent?
No, I was quite naturally talented, and Mr. Brockman was among those who did not see that.
He even said you didn't deserve some of the awards that you won?
Yes, this occurred after I won Best Closer and Best Attorney Award at the Regional Mock Trial Tournament.
He even went as far as to demote you from the team?
Yes, this occurred before those comments.
And your best friend, Taylor Perkins, she had your back, though?
Yes, she took it upon herself to step down from the A team, and I was, as a result, reinstated.
Now, let's talk a little bit about Let's talk a little bit about the practice after regionals. You walked into practice with your head held pretty high.
Yes, I was very proud of my accomplishments.
You were expecting some sort of appreciation from your team and coach?
Yes.
But Mr. Brackman tore you down in front of your whole team.
Yes, it was quite embarrassing, humiliating, and degrading.
You stormed out.
Yes, I did.
You stormed out of practice with that permanent marker in your hand.
It was a permanent marker. However, at the time, I would like to clarify that I did think it was dry erase.
But to clarify, it did end up being a permanent marker.
Yes, unfortunately, it was.
You stormed out of the building.
Yes, as I just said, I did.
And there was Mr. Brackman's obnoxious Porsche.
Yes, I was quite upset at the time, and just the sight of it was quite annoying.
You went up to that Porsche and you wrote Worst Attorney Award on the hood.
Yes, it is a mistake I regret every single day, especially since I was never able to apologize properly.
All 18 letters on the hood of that car.
Yes, I do believe that is 18 letters.
And after Mr. Brackman kicked you off the team, you went home.
Yes, I did.
You told your mom everything.
Not quite everything. No, I did omit the reason why I was kicked off the mock trial team, because at that point I was in denial and still angry.
You were ashamed.
Yes, I was.
Now, let's move on to March 6th. You woke up and couldn't find your phone anywhere.
That is correct.
You spent the whole day with your best friend Taylor looking for it.
That is also correct.
You searched the mall.
And the Fry Shack.
Nowhere to be found.
No, we never located my phone.
Now, let's talk a little bit more about your relationship with Mr. Brackman. When he demoted you, it made you angry.
Yes, I was upset. I did not believe that the B team was an accurate reflection of my talents.
When he humiliated you, it made you angry.
Objection, Your Honor.
What are the grounds for the objection?
For character evidence under Rule 404A1, the evidence of a person's character or trait is not admissible. Prove that on a particular occasion, the person acted.
Miss Nguyen, can you please speak up? We can't, we did not hear that objection. Can you please speak more towards your microphone, please?
Would you like me to repeat? Can you hear me?
We could hear that it was character evidence under 404A1, I believe you said, but we didn't hear the explanation or the argument.
Can you hear me now?
I can, yes.
Okay. Under Rule 404A1, character evidence, the evidence of a person's character is not admissible to prove that on a particular occasion, the person acted in accordance with this trait, and I believe that the prosecution is attempting to prove that the defendant acted in accordance with anger.
And so I was able to catch some of that. Ms. Nguyen, just so you know, it is for some reason, I don't know if something is covering the microphone or anything like that. If you could check that, but I do believe you're saying that the question elicited testimony that the individual being discussed acted in conformity with his character. Is there any response from the prosecution?
Yes, Your Honor. Under 404B2, my witness was testifying, or Avery Becker was testifying to the vandalization of Mr. Brackman's car, and this was the reason that she was kicked off the team. This establishes a motive towards Mr. Brackman.
All right, at this time, I'm going to overrule the objection and allow the witness to answer it.
Could you please re-ask the question?
Yes, of course. When Mr. Brackman humiliated you, this made you angry.
Yes, I was upset by this humiliation.
Lastly, when Mr. Brackman kicked you off the team, this made you upset and angry.
Yes, I was obviously upset. That was 4 years of mock trial, and also my future as a lawyer at that were just kind of kicked out of the window.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor.
You may proceed.
Ms. Becker, what were your emotions when you Mr. Brackman made these comments to you regarding your performance?
I was what I believe understandably hurt and humiliated, especially since he said this in front of my team. It was something that I believe I deserved praise for, and instead I received hurtful comments.
And Ms. Becker, is it reasonable to be angry and upset when somebody makes fun of your work ethic and performance?
I certainly believe so, especially since it was done in front of my entire team. I do believe I was justified in being upset.
Thank you, Your Honor. No further questions.
All right, this witness can step down. At this point in time, we will proceed to closing arguments. Would the prosecution like to proceed?
Yes, Your Honor. And before I proceed, the prosecution would like to reserve any remaining time for rebuttal.
And can we go ahead? Well, we'll do this. Do you need a time check now to know how much time you have in total?
No, Your Honor.
No. Okay, if the timekeepers could just let me know before rebuttal how much time the prosecution has, I would appreciate it. And the time will be reserved. Thank you.
Thank you. May I begin?
You may.
Get out, get in, get even. Ladies and gentlemen, today you heard the story of Mackenzie Brackman. Mackenzie Brackman was a beloved defense attorney, a devoted member of the community, and a local mock trial coach for Colorado High School. Mackenzie Brackman would spend his days tirelessly working to defend people who some others might not even give a second look to. After spending his time defending these people, he donated his free time to the CHS mock trial team. He truly believed in these kids and saw their true potential. But ladies and gentlemen, as you saw today, not all of the kids appreciated Mr. Brackman as their coach. Avery Becker did not appreciate Mr. Brackman as her coach and even went as far as to vandalize his car. Ladies and gentlemen, today you heard the story of how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. You were shown how Avery Becker got into Mr. Brackman's house, and you were shown how Avery Becker got even through trashing Mr. Brackman's house, which resulted in his death. The prosecution called 3 witnesses today. The prosecution called Detective Jordan Markowitz, Kyle Kuzak, and Alex Cifuentes. Detective Jordan Markowitz and Kyle Kuzak showed us how Avery Becker got into Mr. Brackman's house through the ring videos and cell tower data that placed Avery Becker's phone at or around Mr. Brackman's house at the time of the murder. Alex Cifuentes told us how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. Alex Cifuentes also told us about the communication between her and Avery Becker, where Avery Becker told Alex Cifuentes that she was going to get in to Mr. Brackman's house and get even by trashing it. The defense also called 3 witnesses today. The defense called Blake Van Owen, Taylor Perkins, and finally, Avery Becker. Blake Van Owen is getting paid hundreds of dollars to be here today, ladies and gentlemen. And let me remind you, she has only ever testified for the defense. Taylor Perkins is Avery Becker's best friend and would do anything for her. Lastly, Avery Becker is here to save herself, ladies and gentlemen, and that is all she is here today to do. Ladies and gentlemen, today you heard how Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. You were shown how Avery Becker got in to Mr. Brackman's house through the ring videos and cell tower data. And finally, you were shown how Avery Becker got even through trashing Mr. Brackman's house, which resulted in his death. Thank you.
From the defense?
Yes, Your Honor. May it please the court. Your Honor, members of the jury, and opposing counsel. My name is Raina Hilden, and today, along with my co-counsel Cindy Nguyen and Maggie Holland, we have had the honor of representing the defendant of today's case, Avery Becker. You have been reminded throughout today's trial that the prosecution carries the burden of proof, meaning that they must prove beyond a reasonable doubt that Avery Becker is guilty. However, members of the jury, we find in this case not only reasonable, but substantial doubt. Let's talk about the witnesses you have heard from today first. The prosecution brought 3 witnesses to the stand: Detective Markowitz, Kyle Kuzak, and Alex Cifuentes. Detective Markowitz and Kyle Kuzak both were involved in the police investigation, which ultimately failed to prove that Avery Becker was guilty. The only thing that the evidence could show was that, yes, a perpetrator broke into the home of Mackenzie Brackman on March 6, 2020, resulting in his death. However, they failed to prove that this was Avery Becker. Then we come to Alex Cifuentes. At the start of this trial, my co-counsel Cindy Nguyen reminded you to watch out for bias from the prosecution's witnesses. And we find that bias in Alex Cifuentes, who testified today that she would benefit on the mock trial team had Avery not been there. Then the defense's witnesses came to the stand. Professor Blake Van Owen, an expert in her field with extensive experience, demonstrated to you all of the holes in the prosecution's evidence. Taylor Perkins provided an alibi as for Avery Becker's location before the day of the crime, as well as the day of. And finally, Avery Becker testified to you today. She wanted to prove herself to Coach Brackman and make sure that she could finish her senior year on the mock trial team as well as she could have after putting 4 years of hard work into it. Next, let's look at the evidence. First, let's talk about what we don't have here. We do not have an accurate way of placing cell phones based only in cell tower analysis and not accurate GPS data. Next, we don't have any identifiable perpetrator, any identifiable characteristics from the perpetrator. We could not identify any facial features, any pieces of clothing linked to Avery Becker, or any other genetic evidence. We do not have verification on the screenshots of texts which Detective Markowitz depended on for her lead. She testified to you today that she did not consider that verification necessary. Yet another piece of reasonable doubt in this case. And finally, as Professor Blake Van Owen testified today, we do not have all of the evidence. Images of blood splatters were lost during the investigation. Next, let's talk about what we do have. We have an alibi as to the location of Taylor Perkins and Avery Becker on March 6, 2020. We have evidence that Avery Becker's phone was lost the day before, indicating that the location of Miss Becker and the cell phone would not even correlate with one another. And finally, we have a much stronger alternate suspect who the prosecution failed to investigate in Blair Rollins. Professor Blake Van Owen brought forward an audio clip from the trial of Blair Rollins' father, Jonathan Rollins, who threatened Mackenzie Brackman after being sentenced to life in prison. When we compare these two suspects, members of the jury, please consider the weight of their possible motives. And finally, based on all of what we have seen today, we have reasonable doubt because the prosecution jumped to conclusions and fell short. The burden of proof indicates that the prosecution must prove beyond a reasonable doubt that Avery Becker is guilty. Yet, given the amount of doubt that we have seen today, you cannot convict Avery Becker, who is an innocent high schooler being wrongly accused of murder. Opposing counsel claimed that she is only here to save herself, but we have seen that she must save herself from injustice and a false conviction. And for that, we ask that you return with a verdict of not guilty. Thank you.
Thank you, counsel. Any rebuttal closed?
Yes, Your Honor.
You may proceed.
May I proceed? Thank you. Ladies and gentlemen, the defense jumped to conclusions with Blair Rollins and fell short on even finding him. The defense fell short once again when proving Avery Becker's innocence. The defense doesn't even have any hard evidence of Avery's alibi. Ladies and gentlemen, as you heard today, the defense's own expert witness, Blake Van Owen, said that she believed Avery Becker was guilty. The prosecution has proved to you today that it was Avery Becker in Mr. Brackman's home through the Ring videos and cell tower data. Ladies and gentlemen, Avery Becker was told to get out of mock trial and out of Mr. Brackman's life. Avery Becker got into Mr. Brackman's house, and Avery Becker got even by trashing Mr. Brackman's house, which resulted in his death. Ladies and gentlemen, the prosecution asks you to find Avery Becker guilty on all accounts. Thank you.
All right, thank you. We're going to give our scoring panelists just a couple of minutes to enter their scores and then submit them. And if this is okay, what I would ask is for the panelists just to turn their camera on once their ballot has been submitted, maybe, and then we'll wait for Melissa to give us thumbs up so we can give very brief feedback.
Yep. And Judge, if you would like to start with your feedback while the scoring panelists finish, you're free to do that. And then if the scoring panelists will turn their cameras on as they finish, then I can let the committee know that they're done and wait for our dismissal.
Absolutely. Yeah. So I want to step back and just acknowledge how incredible all of you are. You should be so proud of the work that you guys have just done. And I promise you that the work you've done is at a caliber beyond a lot of practicing professional attorneys. You probably hear that a lot, but it's really true. And I just can't believe that I was interacting with high school students, given the level of sophistication and your knowledge. So you have bright futures. That is obvious. 3 pieces of feedback. The big pieces that I would say is on any examination, direct or cross, try to give the jury a heads up what you're about to ask. So, for example, first, I'm going to ask you about your background, training, and experience, and then the jury knows that they're going to hear that. Or on cross-examination, give a little heads up to the jury. I want to talk to you a little bit about your bias in this case, and now the jury knows that's what you're about to ask. So when someone doesn't know a lot about the case, they can kind of start to organize that information. On redirect, watch out for leading questions. If you're looking for somewhere to object, almost always on redirect, people are going to want to ask leading questions. And try to object more spontaneously. You guys did a great job when you did, and I love it. That's when the raw advocacy really gets to come out, and you have to think on your feet and advocate. So think about how you can incorporate those, but you guys were all really, truly tremendous advocates. So thank you for letting me be a part of this.
So we'll just give our scoring panelists a couple more minutes to finish up their scoring sheets, and as they come on, they can begin to give comments, and I will wait on the back end for our ability to dismiss.
Your Honor, if so, I have finished my scoring sheet. So if it's acceptable, I can go ahead and offer some feedback to everybody.
Yeah, that would be great. Yeah, thanks.
So I want to echo everything you just said. I was amazed at the everything. You are all so prepared, and I saw a lot of really thoughtful choices about how to talk on the part of everybody. The attorneys examining, the attorneys cross-examining, the witnesses. I saw a lot of thoughtful choices by everybody about how to present this stuff, and it was all very, very well done. I agree also about the sort of framing what you are presenting. I think I would recommend being more aggressive about somewhat loose use of evidence. If I think, for example, about the video, and the witness testifies, "Oh, there on the video is the defendant." Like, that's the moment. Like, don't let that, you don't let that happen in that moment, rather than let it happen and clean it up later. in part because the objection in the moment, like in the moment, is when people are gonna remember it, and it's hard to unknow something that you've heard, no matter how many times a judge tells you you're supposed to ignore it. And this is not just about the technical rules of evidence, but all the time when you're advocating and debating and making points, you want to get at the moment when somebody is hearing the thing, and sort of that when it's going in the ears is the time that you have to sort of frame how it gets stuck in somebody's brain. But fantastic job by everybody.
You do all do a fantastic job, and I would like to say you guys are probably better at all of this video stuff than some of the attorneys in these courtrooms, for sure. Marion, thank you.
Okay, I don't know what I did with my video, but I can't see myself. Can you see me?
We can see you, yes.
Okay, great. Well, I do also want to add my kudos. This is really an impressive group. And this is, high pressure stuff, a lot to put together, and the quality was great. I don't want to add a lot of time to this. Couple of highlights. I liked early on, Laura, good point on Board Dyer, only 3 days of cell phone training. I liked that. That was just a great point. And there was a lot of poise in that Board Dyer there. There's, again, so many good moments. And then Raina doing the cross of Cusack, really good cadence, really good, just stating the, this is true, and this, and this. And then there was some objections and some things that could have been flustering, but you really kept your cool. So everybody had highlights that were awesome. I just thought I'd point out those two. Thanks.
Great. And then I think, let's see, Deanna?
Hi there, everybody. Sorry about that. I want to say thank you, all of you, for taking the time to stick with this program for as long as you have. I think it's absolutely fantastic that each of you have managed to come this far. And please, from the bottom of my heart, understand that we all understand exactly what it takes for you guys to get to this point. It is a lot of hard work. It is a lot of dedication. It is a lot of sleepless nights. It is a lot of giving up what used to be called free time. Right now, unfortunately, I'm sitting under a massive storm front, and I'm in the foothills. So my internet connection is slightly spotty. So I'm giving up video for voice. First and foremost, to prosecution, excellent use of your theme. Thank you for trying to make sure that it carried through each stage of your prosecution of this case. That is highly unusual. I do not see that often, either in mock trial or in actual litigation. And I've been working in litigation for almost 25 years now. So very nicely done. You guys, you attorneys and your coaches deserve high fives for that. Witnesses for both the prosecution and defense, very nicely done. I appreciated that all of you witnesses were steadfast, that you challenged the attorneys when you could, and that you actually made the attorneys work for it. So very nicely done. To whomever it is that's coaching you witnesses, excellent job. Keep up the good work. I commend you for that. That is actually a very difficult thing to teach. Let's see, for the defense, I don't have a lot of individual praise. I just want to say that I think you all did a very good job of stressing the points that were necessary in order for proving that the prosecution did or did not meet their burden on each particular element. That was also very well done. So I think with that, I'm going to bow out. But again, thank you all, to you and to your coaches and to your families. Thank you all for doing this, and best of luck.
Great. Thank you, everybody. Everybody is kind of finishing all at once right now. So we're just waiting for them to make sure that they can see all of our scoring sheets. So it may be just a couple of minutes if everybody can just hang on for a couple of minutes. And as soon as I get the all clear, then we can get out.
Thanks, Melissa. And is it okay if I turn my camera off at this point?
Yes.
Okay.
Yes.
Everyone stay safe this weekend.
Yes, so if everybody can just stay online, and I am just waiting for the all clear. Sorry, guys, we had like 5 courtrooms all finish right at the same time. All right, it looks like we are all clear. Teams, you should get a message shortly. I'd say within the next 30 minutes or so. Again, everything's coming in at once, so please be patient with us. But thank you all. Thank you to our volunteers for volunteering today. We greatly appreciate your help. The students appreciate you, and we couldn't do this without everyone. So thank you guys so much. Students, great job. I'm constantly impressed by you. So keep up the good work. Take some deep breaths, go drink some water and have a little bit to eat before your next round. And we will keep you guys posted. Thank you, everyone.
Thank you.
Thank you.
You're welcome. Goodbye.